When a de facto relationship or marriage ends, it's often necessary to determine how the couple's assets and financial resources are divided. The term property settlement is used to describe what the division of property between the couple will look like, and will typically encompass such things as real estate, money in the bank, shares, motor vehicles, business interests, household contents, pets, superannuation, the list goes on. But will also include the couple's liabilities, such as taxation debts, personal loans and mortgages. In the family law arena, the governing legislation is the Family Law Act of 1975. This provides a set of general principles that separated couples must consider when determining financial disputes that arise from the breakdown of a relationship. Once a legal or equitable interest has been established, the first factor that must be considered is what exactly is to be included in the parties' asset pool available for division. The process of crystallising the asset pool will require the mandatory exchange of financial disclosure documents between the parties. This includes such things as bank account statements, tax returns, share portfolio statements, loan documents, business and company documents, as well as any other piece of financial documentation that is requested by the other party and is within their power and control to obtain. When there is a dispute regarding an attributable value of an asset, then it may be necessary for both parties to jointly appoint a single expert to prepare a valuation report. The second factor that must be considered in determining a party's entitlement to the net asset pool available for division is the financial and non-financial contributions made by each party to the relationship. Now, financial contributions may include what each party owned at the time that they commenced cohabitation, as well as gifts or inheritances received by a party from their family throughout the relationship. The governing legislation in Australia allows the court to give consideration to non-financial contributions made by a party, such as the parenting and homemaking duties. The implementation of the Family Law Act enables parties to attribute fiscal values to non-economic work undertaken throughout a relationship, the effect being that the indirect contributions are given weight equal to that of the primary income earner. The third factor that must be considered is the future needs of both parties, including their respective ages, their health, earning capacities, financial resources, and who will be providing the ongoing care for the children, if there are any. The fourth factor to consider when formulating a proposed property settlement is whether, under the circumstances and given the previous mentioned considerations, does the proposal represent a fair and equitable division of the assets. It is important to note that each case must be assessed and determined based on its own unique merits. There is no universal formula, and the courts have discretionary powers in this jurisdiction, meaning that what resulted for one person will not be the same experience as that of another, who will undoubtedly have their own set of circumstances and facts. Your situation is individual to you and should be assessed by a family lawyer to give you the most accurate and tailored legal advice.